This video is produced by the law office of Norman Gregory Fernandez, a premier California personal injury law firm. When you file a lawsuit, you don't just show up to court and start yelling. That's for television, not for justice. In the real world, there's a process called discovery. It's the part of the case where both sides are required to show their cards. You ask for documents. You ask questions. You find out what evidence the other side has against you. It's a mandatory, court-supervised process to prevent surprises. You don't get to hide the ball. If you have evidence, you must usually produce it when properly asked. This is where the real work happens, long before you see a judge. Discovery is about getting to the truth. The law office of Norman Gregory Fernandez has handled these matters for nearly 3 decades. They know winning often starts by winning the discovery battle. They know how to get the facts, and how to present them. This is the part of the case where we need your assistance in the case. Now let's talk about a specific and very powerful tool in discovery: requests for admissions, or RFAs. These are not your typical open-ended questions. An RFA is a written statement that you ask the other side to either admit or deny. For example, the other side might send you a request that says, "Admit that you were the driver of the vehicle involved in the accident on January 1st, 2025. Your job is to answer with a straight admit or deny. If you are not able to admit or deny a request, you may state that as a response as well. There's no room for storytelling here. It's a simple, direct question, designed to lock in facts and eliminate issues that don't need to be argued about in court. The purpose of these requests is to streamline the lawsuit. Think of each RFA as a building block in the other side's case. With every admission, you hand them a piece they can use to build their argument against you. That's why you must be extremely careful. You need to understand the legal implications of every single statement before you answer it. A seemingly innocent admission could have disastrous consequences down the line. If your requests for admissions are not responded to within 30 days, they are deemed to be admitted, and you can lose your case. Our office requests that you provide your responses to us no later than 10 days after we send them to you. It takes time for us to convert your responses into normal legal format. Once we receive them, review your responses and serve them on the other side in time. When you receive requests for admissions, you can't just scribble answers on a napkin. There is a formal step-by-step process. If you don't follow it exactly, your answers may not count. Our instructions on how to answer discovery will instruct you how to answer the requests for admissions. Our law office will prepare your responses to requests for admissions once we get them from you. It will have a proper legal caption with the case name, case number, court information. Each response corresponds to the numbered request. For each statement, you have a few possible answers. The most common are admit, deny. If you admit the statement, you are agreeing it is true. If you deny it, you are stating it is false. Answer every single request. Don't skip any. If you fail to respond, it's automatically deemed admitted. A proper response is signed under oath. There's a verification page at the end. You, the party, must sign it, swearing under penalty of perjury that your answers are true and correct. Preparation requires a professional legal eye to protect your rights. In the legal world, a deadline is a cliff, not a guideline. In California, we only have 30 days to respond to requests for admissions, or they are deemed to be admitted. That does not mean you procrastinate until the last minute to give us your responses. We need you to give us your responses within 10 days of us sending you discovery, so we have time to process the discovery. The clock starts ticking the moment the requests are served. The court does not care about your excuses. "I was busy. I didn't understand. I forgot." That will get you nowhere. The deadline is the deadline. Period. If you miss that deadline, the consequences are immediate and severe. Every single request you failed to answer is automatically deemed admitted. Your case could be over before it even begins. On top of losing your case, the judge will likely hit you with monetary sanctions. The experienced team at the law office of Norman Gregory Fernandez knows these rules inside and out. We will ensure your responses are prepared correctly and filed on time and protect your interests so long as you submit your responses to us on time and fully cooperate. Visit thepersonalinjury.com for more information. Do it today. Your discovery responses are critical to your case. If you have questions, call 800-816-1529, extension 0. If for some reason you are not able to do the responses yourself, you may call our office and we will go over it with you over the phone.
You may call us 7 days a week. 24 hours a day on our California Personal Injury Hotline at 800-816-1529. Or go to callnorman.com now.
Callnorman.com. Car accident, slips and falls. There's just one place you should call. Callnorman.com.